subdivision or a project like that that's reviewed under LUPA, you use LUPA. If it's a state agency involved, then you've got the APA. But if you don't fall into one of those statutory administrative review schemes, then you're back on the writ. And you know, counsel said, well, no one brought a motion like this before. Well, I'll say that's true. That's maybe the one thing I agree with what counsel said, was no one has brought a motion like this before. And there's a reason for that, it's because that's not what the statute says. So let's come back and maybe finish with the statute. It says, SEPA is not intended to create a cause of action unrelated to a specific governmental action. It's not creating a separate cause of action. It creates a right of review linked to a challenge to the underlying action. And how do you obtain review of that underlying action? And the way you do that is, in this situation, in some cases is through LUPA, in other cases through the APA, but if those statutes aren't available to you, you do it through a petition for review or potentially the Declaratory Judgment Act. And that's exactly what we've done here. And their novel argument, while it's allowed me to come down and visit Shelton for the day, and I appreciate that opportunity, it doesn't have any legs, and I request that you deny their motion and allow us to proceed with the merits of the case. Thank you.
Okay. We're here today to Shelton's authority to bind itself to a duty to lease property to Adage before it has completed its environmental review. Essentially, the facts are that the court on August 17th, 2010 passed a resolution authorizing them to enter into an option to ground lease with Adage, and that prior to the execution of the ground lease, the optionee shall have applied for and obtained all permits and completed all review under SEPA. The port then entered into an option to ground lease contract with Adage for a consideration of $3,000 per quarter for the first 24 months and $6,000 per quarter for the next 24 months if extended. Exercise of the option is subject to the terms of the resolution, and optionee being in compliance with conditions to include compliance with the requirements of the State Environmental Policy Act. Concerned citizens allege that the court has jurisdiction to review this matter pursuant to a constitutional writ of review, statutory writ, or declaratory judgment. A statutory writ is only available to review quasi-judicial actions under RCW 716.040. And in the case of Harris v. Pierce, they lay out a it looks like a three-step process to determine whether or not something is quasi-judicial versus legislative. Essentially, it comes down to would historically this be the type of action a court would have done. And here we have a port authority passing a resolution entering into an option to lease. That's not the type of thing a court generally has done. Courts do not pass resolutions and lease property. That is normally a legislative function, and therefore the court would deny the statutory writ and dismiss that claim. To seek either a declaratory judgment under RCW 724 or a constitutional writ review, the petitioner must have standing. This threshold requirement is a two-part test. First is the interest that the petitioner is seeking to protect within the zone of interest that the regulation affects, and two, does the petitioner have, quote, an injury in fact? And at this time, I'm just going to assume and use the declarations, although they weren't properly pleaded in the complaint. Several of the declarations provided assert that people live within the distance of the property that's to be developed and have concerns that would be impacted by the building of the facility. For example, the Donaldson declarations state they live within 1,500 feet of the place where the leased property is, and the McBain declarations state they live within 1,000 feet of the leased property. The declarations indicate that these individuals and their families would potentially have their water affected due to where the plant would store wastewater, suffer an increase in noise from the plant, as well as an increase in noise in the traffic, trucks going back and forth during plant's hours of operation, and suffer from air pollution due to the emissions from the plant. The court would find that these type of impacts are within the SEPA zone of interest. But do these actual interests constitute an injury in fact? In this context, where the action complained of here is the port entering into a lease option contract prior to completing SEPA review that requires that the optionee comply with SEPA before it can exercise this option. The injury in fact is defined as an invasion of a legally protected interest which is concrete and particularized, actual and imminent, rather than conjectural or hypothetical, and that there must be a causal connection between injury and conduct complained, so the injury is traceable to the action of the party. If one is alleging a threatened injury versus one already that has occurred, one must show the injury will be immediate, concrete, and specific. The concerns of noise pollution, water pollution, and other environmental harms are threatened injury, and thus petitioner must show that the injury caused as a result of the port entering into an option to ground lease with Adage prior to SEPA being completed will be immediate, concrete, and specific. The action here is the port entering into an option to ground lease contract, in which the exercise of the option can't happen unless there is compliance with SEPA. The injury complained of here is the environmental SEPA concerns that are related and as a result of a facility being built and in operation, and not the leasing of the land. Although immediate doesn't mean that Adage has to actually be breaking ground, i.e. building the plant, for the court to find there is an injury in fact. It does mean that there must be a causal connection between the injury and the act that's uninterrupted such that it is reasonable for one to see that the injury is concrete and specific. What we have here in between the option for the ground lease and the building of the plant is the requirement by Adage that to exercise the option it must comply with SEPA. In other words, if the court doesn't invalidate the option contract, the injury to the petitioner as regards to specific environmental harms, air pollution, water pollution, and noise pollution, may not necessarily follow. The way, for example, that I understand this lease is that the option cannot be exercised until the evaluation is complete and satisfied. This is not to say that those declarations and those concerns provided by the citizens are not valid concerns. The court is not passing judgment on whether or not these concerns will or will not exist. This court is simply stating that for there to be an injury in fact, the injury cannot be speculative and must be immediate and concrete. It would be different if the lease was not an option lease and the court's actions just authorized Adage to begin building without the compliance of SEPA. But because the option can't even be exercised unless there is compliance, it is unknown whether these concerns will materialize. We don't know at this time whether Adage will satisfy SEPA. We don't know if the option will be exercised. What the court essentially did by entering into an option to ground lease was take off the market a piece of property for a period of time in itself, but this is not in itself a violation of SEPA. Thus, in this case, in providing all the cases that the court has read regarding the issue of standing, is more like the Harris versus Pierce case, where the court denied standing because of the risk of eminent domain, which is essentially government taking someone's property, was not final until there was a final engineer report. The court found that the concerns of the citizen were speculative at that time. Based on this, the court cannot find that there is standing. Additionally, a constitutional writ of review on Article 4, Section 6 of our Constitution require that the court find the agency action was arbitrary and capricious, and that there must be a prima facie showing the court's actions were contrary to law and constitute extraordinary circumstances. There's been no showing here that this constitute extraordinary circumstances. The court would deny the constitutional writ. Additionally, the court would find that there is adequate other remedy in law for them to bring the claim under 4321C075. And the court will deny and also grant the motion to dismiss on the declaratory judgment as well. Finally, there was a request made of the court for the issue of attorney's fees. And the request was made by the court. And the law on that is that if an action is frivolous or brought in bad faith, courts are given the authority to grant attorney's fees. This court is not going to grant attorney's fees in this case. This is not the sort of case that the action would warrant fees. This court is reminded, in fact, recently, a review of the cases regarding attorney's fees and find that simply being insufficient is not the same as being frivolous or in bad faith. So I will deny the request for attorney's fees. I will sign the appropriate order. I do have a proposed order. If the parties wish to make some changes on this and circulate it, the court can sign the order.
Is that the one we sent to the ground If I may approach you, I'll review that. I think that's what we just need.